Good morning, everybody, and welcome to our seminar today, our Neighborhood Services virtual seminar. We're going to be talking today about untangling the web and navigating politics and frequently asked questions in HOAs and condominiums. So welcome to everybody who's just joining us. So happy to have you here today. In this class today, we're going to be talking about politics inside and outside of an HOA and condo. We're going to be addressing our firm's most frequently asked questions. And we're going to be talking about just giving a very brief overview. We're going to be having a more detailed class on the new legislation as we get closer to the effective date of the legislation. But we're going to be just touching on that because it's a hot topic because the legislature just closed. So good morning, everybody. Thank you for being here today. Welcome to class number 6 of our firm's 2024 Virtual HOA Condominium Academy. We teach these classes in partnership with the cities of Avondale, Glendale, Chandler, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. And we'd like to give a special shout out to all of those different cities for their partnership with our firm to provide these free classes to board members, homeowners, and property managers. Just some introductions for those of you who may not know me. My name is Beth Mulcahy, and I'm the managing partner and senior attorney for the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed representing HOAs and condominiums for over 27 years, and my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board, and I have for many years. So I think I bring kind of an interesting perspective to teaching these classes because not only am I a lawyer that's in the industry working with associations as their legal counsel for over 25 years, I also have served hard time on my board, 14 plus years total. And so that's given me a good perspective as a board member. And then also I've, been a homeowner in an association and dealt with homeowner issues when I haven't been happy with about how things have been going, for example. So I think what I bring to these classes is for the legal perspective, having some experience serving on a board and also having some experience as a disgruntled owner. Before we get started today, I would like to start off by getting a feel for who is in attendance today. We always like to do a poll at the beginning of our classes so that we determine, who's joining us today. And so the first question is, in which city do you reside? And the second question is, let us know your current role with the association. Okay, let's talk about what's on today's agenda. First, we're going to talk about the main topic of today's class, which is going to be politics inside and outside of an HOA or condo. And we're also going to address our firm's most frequently asked questions. Then we're going to switch over and talk a little bit, just a quick overview of the new laws that are going to be going into effect 90 days from the day the legislature closed. As some of you may know, our legislature closed for the season very recently. And so we're going to be talking about what does that mean for all of us as we're navigating these 7 new bills. And then, as always, there's going to be a free question and answer at the end of the class. So we encourage you to submit your questions now via the Q&A box on Zoom or in the comments section on Facebook Live. And we'll be sure to answer all of your legal questions during this session today. The only caveat we have is please limit yourself to 1 question per person. And please be as specific as possible when you're asking the questions, because it's very hard for me to ask follow-up questions when we're in a live virtual format like this. Okay, let's switch gears and talk a little bit about our main topics for today. And like I said, then we're going to get to the hot topics of our new legislation that everybody's talking about, right? Okay, so let's first start out with politics and associations. I'm going to give you kind of like some general things, that you need to know about managing politics in associations. And obviously we've got political elections coming up here very soon. And so, that's obviously a hot topic, but let's just talk generally speaking about politics. How do we navigate politics in associations? And I'm not talking about like national politics, right? For associations, I'm talking about the internal workings, the internal politics of association. And so let's just talk about that a little bit. Every association, whether you like it or not, probably has some form of politicking going on And maybe there's warring groups over whether or not to levy a special assessment, or maybe there's, just a general, disagreement between community members about what's best for the association. Just some general thoughts before we get into, politics and associations would be, try your best to go back to the basics. So I'm from Wisconsin. I always like to talk about, let's get back to the basics. So the basics here would be, why are we all on the board? And why do we want to live in this community? The basics are that we all want what's best for our community. And so when you're serving on your board, you're not doing it because you love to, give up 10 hours a month plus handling association issues, right? You do it because you love your community. You do it because you want to make a difference and you want to see things being run well. You want the common areas to be maintained. So if you always go back to the basics when there's politicking going on, it gets everybody centered and it makes everybody realize that, okay, we do have commonality, right? This is just like the politics on federal and state levels, right? We have to cross the lines, right? When there's a disagreement in associations, and we have to find common ground. And the common ground is, hey, we are all serving our community because we want what's best. And to that end, we may not all agree on how to get to the best result, but what we do agree on is that as we're making decisions, we're all trying to do what's best for our community. And so that's kind of an important thing to remember as you're making decisions, and try not to get on that political divide line. Like, I want the special assessment. I don't want the special assessment. We want to do one thing and another side wants to do another thing, or, we think we should sell this common area asset and we don't think we should sell it, whatever. Try to get away from that and try to get to a more common ground of, let's all try to make the best decision for our community after evaluating all the facts. And let's reach out to our trusted advisors who aren't involved in any of the politics and get their feedback about the raw data, the raw information, and, see what their opinion is on it, and try to separate, any personality conflicts, et cetera, so that you can all work together. So that was just kind of like my little introductory mark on politics and associations. Let's go back to the poll real quickly so that we know who's here today. We have a great turnout this week. And so the first question is, which city do you reside in? And we have 11% here today from Chandler. We have 2% from Glendale. We have 6% from Goodyear, 25% from Mesa, 6% from Peoria, 18% from Phoenix, 17% from Scottsdale, 10% from Surprise, and 5% from Tempe. So great job. Lots of different people here today. Also, I'm hearing from my staff that we have over 200 attendees here today for our neighborhood services class today. So that's awesome. Thank you so much, everybody, for being here. I know it's hot outside, and I appreciate you staying cool and, learning more about your HOAs and condominiums and how you can help them. Okay, the second poll question is, who's here today? So we have 65% of our guests are board members, 6% are community managers, and 25% are interested homeowners, and 4% other. So I would say today we have a lot of, a little bit larger representation than normal of interested homeowners. So we always have a lot of board members and we always have a sprinkling of community managers, but awesome to see so many interested homeowners. Okay, so we have kind of just did our little introductory remarks, right, on, politics and associations. And, my suggestion to you that we get back to the basics and remember why we're serving on the board. Trying to find commonality, and the common ground is we all want what's best for our community. No matter everybody thinks there may be a different way to get there, but we need to go back to the basics and find the common ground reason why we're here, and listen to all arguments, be respectful, reach out to your trusted advisors for help. Okay, let's talk a little bit about our upcoming election season, right? We are starting to get questions about a number of different things. So we're going to be talking about politics, maybe outside influence politics, and how that may impact your association and what the laws are so that you're aware of them as we navigate, the next 6 months of political activity. Well, first, as a starting point, we're starting to get questions on upside down United States flags. We have consistently had questions, over the past 4 years about political signs, political flags, flying flags that are regarding political candidates, or maybe flags that may have messages with hidden meanings, etc. I guess the first thing that I would say is, as a general rule, association boards should stay uninvolved as much as possible in any political elections. It's my opinion that the board should not be supporting any, specific local, state, or federal candidate, and, announcing that, our job is to run the association. We stay out of, local and state and national politics, right? The other things that we should be thinking about is that as a board, we need to know what the laws are in Arizona that may pertain to political things that homeowners may want to do. And so, we're going to be the next 6 months. I'm telling you, you will be tested on this, and we want to make sure that you're aware of all the different laws that pertain to many of these political issues. The first one is we're going to talk a little bit about the political sign law, because I think that's the one that you're going to see quite a bit of this in the next 6 months. So under Arizona law, which is 33-1261 for condominiums and 33-1808 for HOAs, there's a special law under the Condo Act and the Planned Communities Act that talks about political signs. And basically what this says is, regardless of what your documents state, so no matter what your documents state about political signs, this law is going to trump that. And basically what that means is that an association shall not prohibit indoor or outdoor display of a political sign by an association member on the member's property, except that an association can prohibit the display of political signs in these following ways. So earlier than 71 days before the day of a primary election, the association, can prohibit the display of the flag. Another time they can prohibit it is later than 15 days after the day for the general election. And then for a sign for a candidate in a primary election who does not advance to the general election, we can prohibit the display of a political sign later than 15 days after the primary election. So we also can restrict the size and number of political signs that may be placed on a member's property. However, our restrictions cannot be more restrictive than any applicable city, town, or county ordinance that regulates the same. And in my experience, the city, town, and county ordinances are pretty lenient. So whatever city that you live in, if you're having a problem with political flags, you may want to reach out to your city, town, or municipality, or the county if you live in the county, and find out specifically what their rules are on, or the ordinances are on political flags. And then you can determine if the owner in your association is complying with that. If the city, town, or county does not regulate the size and number of political signs on a property, then an HOA or condo can only regulate signs to the point where the aggregate total dimensions of all political signs cannot exceed 9 square feet. Although this isn't a requirement, HOAs and condos may want to consider including provisions in their rules and regulations that are consistent with this law. Or you may want to start talking about this in your, newsletters or on your website or whatever, if you're having issues with flags, so that everybody's aware of what the law says. I think on political signage, if you have any problematic political signage, what you may want to do is you may want to reach out to your trusted advisors, your attorney, or your management company to get advice on how to best handle it. Because sometimes the questions are kind of unusual. Like I remember 4 years ago, we had, like homemade political signs for candidates, et cetera. And we had some kind of unusual situations that came up. One other little caveat on this I want to mention, not just for local, state, and national elections, sometimes we're starting to see now political signs in associations, whether it's a condo or a planned community, for elections or for initiatives that pertain just to association issues. So Johnny Appleseed is running for the board, and we're starting to see, signs, I support Johnny, or Appleseed for HOA board, or whatever the issue is. Under the law that was amended a couple of years ago, homeowners can place on their property signs for, the political elections of your board members, or for political initiatives within your community, like remove Johnny Appleseed from the board, or vote yes on the special assessment, or whatever. Although those are kind of few and far between, we haven't seen a lot of associations doing that. I just want you to be aware that that is something that is allowable under the Planned Communities Act and the Condominium Act. Okay, let's talk a little bit about flag displays next. So the law that pertains to this is 33-1261 and 33-1808. And this law specifically talks about, in planned communities and condos, what associations can regulate with regard to flag displays. So there are certain flags that are protected and that can be flown at any time on the owner's property, and that would be like the American flag or any replica of a flag of the Uniformed Services of the United States. However, the flag must be displayed in a manner consistent with the federal flag code. The POW/MIA flag is allowable, the Arizona state flag, Arizona Indian Nations flag, the Gadsden flag, a first responder flag, and a blue service flag or a gold star service flag. And then any historic version of the American flag, including the Betsy Ross flag, without regard to how the stars and stripes are arranged on the flag. HOAs and condos can place limited restrictions on flags, such as that only 2 flags can be displayed at once, and that the height of the flagpole cannot exceed the height of the roof of the residence on the lot if you live in a planned community. Recently, like I said earlier in the introduction, we've been seeing an uptick in questions from associations about people that are flying United States flags upside down. The United States Code on the Federal Flag Code is very clear that a flag is not to be flown with the union down unless the nation is in distress. Even though HOAs and condominiums, can restrict or prohibit owners from flying the flag upside down, the question is whether you want to is kind of entirely different. There are several, what we would say is that this is probably something that is going to make the news. And is this a battle that you want to pick? I think is something that your association is going to need to determine. You may want to reach out to your trusted advisors to talk about this a little bit more. But we are starting to see questions on upside down US flag for sure. I've had 5 or 6 just in the past 2 weeks alone. And I guess what we've been advising our clients that are coming to us with this question is, we've said, okay, what I would recommend is that you pick up the phone or you send just a courtesy reminder letter to these people that are doing this and remind them that, under the federal flag code, this can't be done unless the nation is under distress. And that, we would ask them to please be respectful of the United States flag. Now, if they don't fix it after that, then you're going to have to decide, are we going to take legal action? Are we going to, send a more formal letter? Are we going to fine? I really don't think that's a battle that you want to pick right now. A lot of associations, 4.5 years ago, we had similar questions, with the last national election. And I think we navigated the issue really well. We just kind of didn't get too involved in, some of these flags that were being flown, et cetera, unless they were offensive to somebody else. Now, as an American and as a patriot myself, I do not like to see the flag being flown upside down. But it's a sign of the times. I hate to say that. It's something that's, we're going to start seeing in our country, I think. And we just have to navigate it as an HOA and condo and decide, hey, do we want to spend, $400,000 in legal fees fighting about this? I'm guessing probably not, because we don't have that type of budget in associations. So I just want to make you aware that this is happening out there. And our general advice is try to resolve it amicably with the owner. We don't really want to get into a First Amendment right to fly the flag upside down as a form of protest, and whether or not our country is under distress or whatever. It's just not something that I think our HOA has the legal bandwidth to fight. And I think it would not be a good business judgment to do that. So, okay, let's talk a little bit about political expression at board meetings. And so we have a great cheat sheet on the Arizona open meeting law and rules for recording association meetings that my team is going to be sharing with you shortly if they haven't already. So remember that usually how board meetings work is that the board allows the owners to have a homeowner forum at the beginning of the class. And during the homeowner forum, owners are allowed to, for a minute or so or 2 minutes, depending on how long the board allowed to, make statements regarding the community or ask questions or express their opinions. And so there are times where you're going to have political expression. Maybe it's an association issue, maybe it's another issue at your board meeting. And so I think basically what I would recommend is, have the homeowner forum, maybe announce at the beginning of the homeowner forum that, hey, the discussions here today are going to be limited to association business, and we're going to be respectful of each other, and we're not going to have raised voices. Just have a certain time period that owners are allowed to speak, and a special time slot at the beginning of the meeting is usually what I suggest. You don't have to respond as a board to every single comment that homeowners make. You can just say, thank you so much for being here, and we appreciate your feedback, or thank you so much for being here, and we welcome your opinion. You don't have to get into a back and forth on this, but we have had situations where owners are coming to the meetings and expressing political views on state, local, federal issues. Also, just on association political issues. And people are allowed to, have their opinion, and a good time to allow them to give that opinion is during the homeowner forum. But again, just some kind of protections for the board would be put a time limit on how long they can talk. And don't feel like you have to engage in any dialogue other than thank you so much for being here and thank you for your feedback. Okay, we have some other additional legal concerns that I want to just mention here today. So Arizona Revised Statutes 33-1808, which applies to planned communities, has some other restrictions to keep in mind. HOAs and condos cannot require that political signs are commercially produced or professionally manufactured. And so that's important for us to, know under the law that in a condominium and a planned community, we can't make them be, professionally manufactured signs. We also cannot regulate the number of candidates supported, the number of public officers supported or opposed in a recall, or the number of propositions supported or opposed on one political sign. So we kind of get back to those homemade signs. If they want to have lots of language on it, as long as it complies with what the, city, town, or county's ordinances for total size, or, then it's, anything goes, that's okay. Also, HOAs and condos are limited in how we can regulate door-to-door political activity. And so this could be the situation where we have maybe somebody coming around your neighborhood with a political proposition that they want people to sign. And so here's a couple, thoughts on this. HOAs and condos, can regulate door-to-door political activity in the following ways. So we can restrict or prohibit door-to-door activity from sunset to sunrise. So once it gets dark, you can't have people, knocking on the doors to enter the community. We can require a prominent display of an identification tag for people engaged in this activity. And we can prohibit a person who is not accompanied by a member or resident of the planned community if the planned community regularly restricts vehicular or pedestrian access. So if you have gates and it's not, like a public area where people can just walk into, then if somebody wants to do door-to-door political activity, they have to be accompanied by a, member of the association or a resident in the association as they're going door-to-door. So the gate, at the entry gate, guard gated entry does protect the association from having just people wander in unless they're with a member of the association or a resident in the association. So what do we talk about? Just some key takeaways on these political issues. Just a couple things. Number one, be reasonable. Reach out to your trusted advisors when you have a question that you're like, gosh, I don't know how to handle this. Contact your attorney, talk with your management company, and get their opinion on what's the best way to handle this political situation in my association. Remember, if it's politicking within your association, try to find that common ground. Go back to the reason why we're all serving on the board. It's because we want what's best for our community. Try to agree on the things that you can agree on, and maybe on the things that you disagree on as a board. Then reach out to your advisors to give their opinion, their unbiased opinion based on facts as to what's the best way to handle it. Tread lightly. These are kind of going to be difficult times, I think, for some associations in the next 6 months, 7 months. People may be testing things like flying the flag upside down, or maybe they, as the national election gets closer, we may start to see some new trends of things that people are doing. We don't want to be on the news, right? That's the key thing that I would say for most associations. Try your best not to be on the state or local news, because that is just bad publicity for your community. And it's going to be expensive potentially if there's a lawsuit that is a result of, negative publicity and the owner, wanting to pursue the matter further. So tread lightly, talk to your key advisors, your trusted advisors to help you. Be careful of selective enforcement. We don't want, we have to enforce violations in a uniform way. And so we, definitely want to make sure that we are treating each homeowner's violation and similar violations in a similar manner. And we couldn't act, like for one candidate, we couldn't say, oh, they have to take down all their signs, but then the other candidate's signs get to stay. You don't ever want to get into something like that. Do your best to be united as a board. No matter how you feel about a political issue, try to be united in the fact that we all want to do what's best for the community. And really, I advise association boards from, going on Facebook or Nextdoor and duking it out, fighting it out on issues that involve your community. That's really unprofessional, potentially even a breach of fiduciary responsibility. Much better choice would be to professionally and rationally discuss it at a board meeting. So that's just kind of our quick little 411 on political, political issues in a community. One more thing that I want to mention. So in the last election cycle, we saw a lot of flags, and sometimes the flag has a political message on it, like so-and-so for president or whatever. In the last election cycle 4 years ago, the federal election cycle, we treated that like a political sign, even though, like, as we talked about today, the flags that are protected, we listed all of them. It's, the United States flag, it's the Indian Nations flag, it's the Arizona State flag, et cetera, et cetera, et cetera. You don't see a political candidate flag on that list, right? But I do think that if this was tested in court, if a judge looked at this, the owner's ability to display a, political sign as a flag, I think that they would read both statutes together, and I think that we would be required to allow that political flag. Now, the only exception I'm going to make on that is if the flag contains some sort of offensive language or has some sort of offensive meaning, then I think that the association could demand that the owner take the flag down. Okay, let's switch gears and talk a little bit about what are some really common questions that our firm is receiving right now regarding associations. So kind of the first one that I think we're getting a lot of questions on is the Corporate Transparency Act. And, does this apply to associations? What is this unconstitutional case, that was decided a few months ago? What does that mean for us? So, basically, yes, it does apply to associations right now. And yes, as of right now, you are going to have to file a form by January 1st, 2025 that tells more information about your association and the individual board members. However, to counter that, what I'm suggesting that associations do And just to give you a little backup on this law, in case you're not familiar with it and you're joining us today, the United States Congress passed a law that, basically was to keep better track of corporations because of money laundering and terrorism. I do not think in a million years that the United States Congress planned to have this apply to HOAs and condominiums in Arizona, right? I think the way that they wrote the law, it put a lot of nonprofit corporations under the umbrella of this law. And so we're all trying to navigate, what does this mean for us, right? Like, do we have to comply? So short answer is, as of right now, yes. We have to comply by January 1st, 2025. So my best advice, if anyone's asking me how I feel about this, would be just take a wait and see approach. Wait until December 1st, 2024. We're going to be pumping out a ton of information, at that time as to how to fill out the forms, et cetera, the different companies that will fill out the form and update it for you. And take a wait and see approach until December 1st. It's a very simple form to fill it out. I filled it out, myself already once just to see how long it took. It was less than 5 minutes. And I did not think that the questions were overly intrusive about, it's just basically contact information for, board members and, LLC members, et cetera. Okay, a couple things you need to know about the law. There has been some challenges to this law already, and the challenges have resulted in a federal court ruled on March 1st, 2024, that the Corporate Transparency Act was unconstitutional, and lacked a sufficient nexus to any enumerated power to be a necessary or proper means of achieving Congress's policy goals. And of course, the government appealed that decision, in mid-March. So we're waiting to see what happens on that. CAI, which is the Community Associations Institute, which is a national think tank, which is an amazing, resource for all of us. They have been, very advocating strongly that this law should not apply to HOAs and condominiums in the United States. Just because that particular case was deemed unconstitutional by that court, the Financial Crimes Enforcement Network, which is where all this paperwork is going to go to for the federal government, has said that, okay, this opinion, this lawsuit opinion, only applies to the plaintiffs in this action and does not universally apply to this law. And so, this is going to be duked out in court, right? And we're just going to have to wait and see what happens. I know that there's all kinds of amicus briefs, which is a brief that's filed by different organizations to support or oppose decisions that have been decided. Community Associations Institute did file an amicus brief on May 20th, 2024 in United States Court of Appeals, 11th Circuit, in the National Small Business United case, which was the case that was overturned, that the judge overturned this new law. We're just going to have to take a wait and see approach. So just the quick skinny on this is, as of right now, you have to follow it. Stay tuned because, we think by December 1st, there'll be better, feedback as to who specifically, is going to need to comply with this and who isn't. As of right now, associations do need to comply with it. And, I'm hopeful that the government is going to wake up and realize that the HOAs and condominiums throughout the United States are not, any sort of a terrorist money laundering organization, and do a carve out for us, possibly this fall. When the legislature is back in session, to carve the many different entities out of this compliance with this law. Okay, let's see. Let's talk a little bit about records requests, because that's another common question that I get. So what records can an owner see if they want to? So owners have a right to see basically everything, right? They have a lot of leeway on this. There's a few small areas that they can't see records for. But remember, this is their corporation too. And so if they want to see records that aren't protected by statute, they certainly can. And so what are some typical things that if an owner requests, they should be allowed to see? So the financial statement for the association, the year-to-date budget, bank statements, anything in their individual lot file for the association. They can see contracts that are signed by the association. The only thing they can't see on the contract is how much is being paid to the vendor. However, I usually tell the board just give it to them because they can find it in a couple different places on the bank statement, on the year-to-date budget. But if you want to play, the you can't have it game, you can blacken out or redact on the contract how much that vendor is being paid, and you can, then they can't have that information. There are some things that they cannot have. And just kind of to back up a second, once someone makes a records request, we have 10 business days to provide the records to whoever the requesting owner is, and only the owner can make the request. So you have to calendar that the day it comes in and make sure that you respond within 10 business days. Also, we can charge, if they want copies of the paperwork, we can charge 15 cents per page, or they can just come to the office of the association or the management company and review the records without having to make copies. Whatever the homeowner requests is what we should comply with. I mean, there are some things that they can't have, and let's talk a little bit about that. So if a homeowner makes a request to see attorney-client privileged information, they can't have that. They cannot have anything on litigation that's pending. So anything that's open litigation right now, they can't have anything in our records on that. They cannot have executive session meeting minutes, another thing that is something that they are not allowed to have under the law. They can't have any information regarding the personal, health, or financial records of an individual member of the association, an individual employee of the association, or an individual employee of a contractor for the association. So the most common things I would say that would fall under that would be like emails of owners and cell phone numbers of owners, and landlines if people still have a landline phone number. The only way that owners would be allowed to request that information and the association would provide that personal information would be if the owner had agreed in writing to put that in like the owner directory or something. Then they've waived that right and we would give that. But otherwise, that's going to be personal health or financial information that we're not going to give to a requesting owner. Anything regarding job performance of an employee or an independent contractor of the association, compensation of an employee or an independent contractor of the association, or any complaints that there may be against an employee or an independent contractor of the association. Again, I just want to caution you that whenever someone makes a request to find out like how much, the management company's paid, or how much the landscaper makes each month, or how much, the general manager might make. There's lots of places they can look in our records to find that information. So it might just be easier just to provide it so that we have an air of transparency and people aren't thinking that we're trying to hide anything. They can find it in the year-to-date budget. Typically, they can find it if they look at, the financial statement for the association, the bank statement for the association. So there's lots of different ways that they might be able to find that information already. So why hide the ball? Okay, some common examples of other common examples I can give you of records that are typically requested would be regular board meeting minutes. Owners are allowed to see, right? Year-to-date budgets, bank statements, balance sheets, check registers, audit reviews or compilations that are done every year. Those would all be things that owners should be allowed to see if they requested. An owner's roster with the owner's name and their property address, they should be allowed to see. Some common examples of things that we don't typically allow owners to have. It's in the board's discretion though, but under the law, we can say, no, you can't have this, are going to be executive session meeting minutes. We talked about that a minute ago. Attorney-client privileged information, and anything pending litigation, whether it's the lot file for a lot that's involved in pending litigation. Performance reviews of employees would not be allowable. Complaints against employees or independent contractors wouldn't be allowable. But I will say, just in closing on this topic, that 95% of the documents that we have for an association are discoverable, and we do have to provide. So just keep that in mind. This is the owner's corporation, right? That's how corporations work. Each person owns, their share or their lot in the association, and they certainly have the rights to see how things are being run and how their money is being spent. It's important to note, one question that I get often that I just want to mention is, what do you do if records are damaged and they're thrown out or something, or the document just doesn't exist that the person is requesting? Basically, the way to handle that is to just notify the requesting owner that the document doesn't exist anymore. Either it was damaged and the box was thrown out, or we just don't even have that document. So that's a valid answer to a records request. Now, obviously, you can't be playing hide the ball, right? You have to actually the record has to actually not exist for you to say something like that. What do you do if, we have a lot of owners here today. So what do we do if we have a board that is not giving you records that you're entitled to, that we've talked about here today? So, you're making requests to see the regular meeting minutes, or you want to see the documents of the corporation, or you want to see the bank statements, and the board is just refusing. So what are your legal remedies? So you can file a lawsuit, right? You can go to, in Superior Court, you can go to the Arizona Department of Real Estate and, file a complaint there and ask for an administrative law judge to review the issue. You should be documenting in writing, like your request should be in writing. And if they're failing to give it to you, you should be responding back to them in writing, letting them know that you want these documents and they're not be provided, and that you are entitled to them under the law, so that you have that paper trail if you decide to go legal and go to the Arizona Department of Real Estate and file a complaint, or to Superior Court and file a complaint compelling them to give it to you. Okay, another hot topic that a commonly asked question that we get is removal of the board from office. So we've seen kind of an uptick in removal petitions, et cetera, that have been, sent to associations recently. So we thought this would just be a good time to just do a quick little refresher. So when does this come into play? This typically comes into play when you have a group of owners who are unhappy with how things are being run, and they start, circulating a removal petition pursuant to state law, around your community to get the director or directors removed from office. One thing that I'm just going to mention is that removal meetings are not a good thing for associations. And here's why: because it's very divisive for your community. It tears the fiber of the community apart. You start to get a bad reputation with realtors that, like, oh my gosh, this community has so many problems. They're fighting. There's a recall petition going, and people may have difficulty selling their homes. Also, they're really expensive. The legal fees to manage and help an association with a removal meeting are going to be somewhere between $4,000 and $10,000, just to help the board navigate the entire process from A to Z. So it's not a good thing. So if you are on your board and you're hearing about a removal petition that has been circulated around your community, now would be a very good time for you to get out there and have a town hall meeting and talk about what's going on in your community. Get yourself out there as a board and find out why people are upset, and try to answer questions and calm people down. Whenever I have a board call me and say, hey, we heard there's a recall petition, going around the neighborhood, I recommend that they immediately have a town hall meeting, or immediately start increasing the amount of communication that they have to the owners, asking them to come to board meetings, talking about divisive issues in the community. You may even want to have a little meeting with people that are running the recall and see if you can try to find some common ground. But if you can't, and the petition, moves forward, I just want to make you aware of the law on this. So what does the law say? So we have a special law that pertains to removal of directors from office, and it's in the Condominium Act and the Planned Communities Act. And basically, in the Planned Communities Act, it's 33-1813 for planned communities. And in the Condo Act, it's 33-1243 for condominiums. And basically what the law says is that after the developer appointed board is, when we go to the homeowner controlled board, this law applies. And basically this law trumps any provision that you may have in your bylaws or in your CC&Rs regarding removal of directors. So Arizona law has a law that trumps no matter what your documents say. Here's a quick recap of what the law says. So if you want to remove a director from office, Basically, you have a group of people that are, circulating a petition around your community saying, I would like, 2 board members listed by name to be removed from the office. It doesn't have to be a cause. You can just say, we just want them removed. You don't have to give a reason, although most people won't sign it, I think, unless you have a reason, but you don't have to have a reason to remove them. You have to hit a certain benchmark in terms of, how many signatures you need on the petition. So for associations with 1,000 or fewer members, you need to have 25% of the votes in the association or 100 votes in the association sign the petition. If you have, over 1,000 lots or units in your association, it's either 10% of the votes in the association or 1,000 votes, whichever is greater. So once we get that petition submitted, and remember, if you're circulating the petition as a homeowner to remove the board, you probably want to get a little more than the percentage that you need, because some of those signatures could be thrown out because maybe it's a renter that signed it and only record owners are the ones that are valid signatures. Also, if an owner is delinquent in payment of assessments or they're not in good standing and there's a provision in your documents that allows you to, suspend voting privileges for that, their signature may be thrown off of the petition because they're not in good standing. So you want to have a little buffer zones there so that once you submit the petition, if some are thrown out, you still have the requisite number that you need. Okay, so what do we do once the board gets the petition? The first call I would make would be contact your attorney and get them involved. Typically what happens is the petition is given to our office as the attorney, and we verify the signatures one by one. We check to see if the owner that signed the petition, well, first, are they an owner? Second, are they a record owner, right? So it has to be, their name has to be listed on the deed. If it's like an LLC or a trust or something, we have to do a little more research to make sure that whoever signed on behalf of that unit or lot is in fact able to sign. And then we check to see if the governing documents have a provision that allows the association to suspend voting rights. And if that's the case, then we check to see if they're delinquent or have any other reason why their voting rights have been suspended. So first step is we verify, did they actually have the percentage of votes that they needed to, move forward with the removal petition. Sometimes, it's pretty infrequent, but sometimes they don't have enough signatures. And so what we recommend that associations do after we review it and we say, hey, they don't have the signatures, is we write a letter to the people that, went door to door to get the petition and explain to them why it didn't, meet the requirements of the law to have the removal meeting. And we let them know that, you didn't meet the requirements, and for the rest of the term of these board members that you were trying to remove, you cannot resubmit another removal petition. So, that's a very, that's just what the law says. And sometimes, when you have a group of disgruntled owners that are circulating a petition, they're going to be really unhappy when they hear that. And so that is an opportunity for the board to, provide an olive branch to this group to try to work with them. It's not an opportunity to stick it to them, right? I think if there's enough dissatisfaction that you had pretty close to having the requisite number of the homeowners in the community signing a petition to remove a board member or board members, plural, there's a general sense of dissatisfaction about how things are going, and you need to communicate more and be as reasonable as possible with your homeowners so that they feel that they're being heard and so that they feel that you're doing a good job for your community. So even if that petition fails, the board should actually be kind of having a meeting with themselves and saying, okay, where did we go wrong here? And how can we make this situation better going forward? If, on the other hand, the petition is valid and we're moving forward with a recall meeting, we have to notice the meeting and conduct a special meeting of the membership within 30 days of receiving the petition. There was a law passed last year that says if we don't do it within the 30 days of receiving the petition, the entire board is removed. So it's very serious. This is a very, very serious deadline with consequences. So, as soon as that petition comes in, we got to crank through, verifying those signatures within 1 to 3 days. And then if it's valid, then we have to get that notice of the meeting out as soon as possible, secure the location, do an absentee ballot to accompany the notice of the meeting, and move forward within 30 days of receiving the petition. So this is a very short frame time. It's like planning an annual meeting on an expedited basis. So, it's urgent. It's not something that you put on the side of your desk and come back to later. Okay, let's talk a little bit about the actual meeting. So the night of the meeting, or the day of the meeting, whatever it is, most people will return their ballots by absentee ballot, in my experience. Some people will show up because this is kind of like the social event of the year at your association. Basically at that meeting, you have to have a quorum of members present, and there's a special quorum for removal meetings. It's 20%. So once you have that quorum for the special meeting of the membership to remove a director or directors, once you have that quorum, then at the meeting, you have people cast their ballots, or if there's absentee ballots, those are counted after we get the ballots that are cast at night. And you need a majority of those who voted to vote in favor of removing a director from office. And in my 27 plus years experience representing associations, I can tell you that it's pretty hard to remove a director because honestly, nobody else wants your job. And so you have to be really, offensive, or really, they have to really disagree with how you're handling things, because the reality is they don't really want to do your job, but they want to get your attention and say, hey, we don't like this and we want this direction change. So that's kind of sometimes the message that I think we're getting as a board. If you're getting a removal petition, that's the message that you're hearing. And if they really don't like you, then unfortunately you will be removed by a majority of the owners at that meeting. So just some things to think about. So what happens if you go to the removal meeting and the directors are retained? They are not removed. It's business as usual. You just get back to business. But again, as legal counsel for an association, I would say, hey, you really need to take a look in the mirror and figure out where the wheels came off the bus and try to rectify the situation so that we don't have so many people who are upset. If you are removed, or maybe one board member is removed, there's a special way to handle how we replace that person. So on removal of at least one, but fewer than a majority of the members of the board, the vacancies are filled pursuant to the association's documents, which means that typically the association's board appoints the replacement for the person who's been removed. But if a majority of the board has been removed, then you need to go on and have a special meeting of the membership. Unless the board or if the association documents do not provide a method of filling board vacancies. So like in the first case, if it's less than a majority, but the documents don't talk about how to fill a vacancy on the board, most do. But then you have to go to a special election to find a place to find new candidates to serve on these vacant board positions. I don't think since this new law went into effect, I think maybe only a handful of times I've had that actually happen. So in like 8 or 9 years, I've only seen this actually happen, where people are removed and then we actually have to have a special election to re-elect new board members. If the entire board is removed, it's really kind of a sticky wicket. Typically, the legal counsel for the association and the management company work together to have a special election to re-elect, new board, or to elect new board members. A couple things. If a board member is removed from office, they can't run again for the board until their original term that they were elected to has finished. So, that's important for you to hear. They will not be able to run again for the board until that initial term that they would have served if they had not been removed is over. That's basically the answer on that. You have to keep the records from the removal meeting for at least a year, so you can't be throwing them out or tossing them. Owners can request to see the ballots, see how people voted. It doesn't happen very often, but I want to make that clear because that does come up from time to time. Okay, a few more frequently asked questions, and then we're going to move into talking a little bit about the new legislation. So let's talk a little bit about the open meeting law. Remember that under Arizona law, we have a special open meeting law, which is different from the open meeting law for school boards or city council meetings. And basically what our open meeting law says is that anytime a quorum of the board is meeting to discuss association business, the board needs to give 48 hours notice to the membership that they're going to be conducting a board meeting. And that notice can be given by putting it on the newsletter, putting it on out by email. You could put it on your website. You can post it at your association's property, on your bulletin board, or on a sandwich board. All of those things are valid, ways to give notice. And so owners should be allowed to attend, listen, and participate at appropriate times during the meeting. And like we talked a little bit about earlier in this session, you can have a homeowner forum and have the homeowners talk, during that time period is a good way to do it. A couple of things that you should know is that the board can go into what we call executive session, which is just the board and maybe a special guest that they may invite to discuss certain topics. The most common topics that we have for executive session are legal advice from an attorney for the board or the association, any pending or contemplated litigation. So if we're actually suing someone or we're thinking about suing them, we can go into executive session. Any personal health or financial information about an owner, an independent contractor, or an employee of the association, we can discuss that in executive session. Matters relating to the job performance of, compensation of, complaints against, or health records of specific employees of the association, or an individual employee of an independent contractor for the association. These are all things we can go into executive session for. Now, it's really pretty limited. I mean, most of our clients who are HOAs or condos, they go into executive session to talk about delinquencies, violations, advice from their attorney. Maybe they have a problem with a vendor, maybe they have a problem with an employee. Those are the most common things to go into executive session for. Also, you can, if a member appeals something and the board wants to hear that appeal, in executive session, the board certainly has the right to do that. The only exception is if the owner says, oh no, I want this in the open session, then we've got to move it to the open session if you're having an appeal of an owner for a violation. Just kind of a interesting fact there. Remember, before you enter into your executive session, the board is required by law to identify the section under the open meeting law that they're going into executive session for. So a really good way to do that is just put it on the meeting notice for the open meeting and say, at the end of the meeting, we're going into executive session and we're going to be discussing these topics. And then list the statute number, which is 33-1804 if you're a planned community, or 33-1248 if you're a condominium, and then the actual section numbers from those two laws that you're going to be going into executive session to discuss. So that's a really good overview of the open meeting law. Just some reminders: be careful of using email to make decisions as a board. That's a big no-no. Remember that you can go and have an emergency meeting and suspend the 48 hours notice if it's a true emergency and you cannot wait 48 hours to make a decision. And remember that association meetings must be held in Arizona, kind of with Zoom. That's kind of a little bit of a weird situation now, but there should be at least one spot if somebody wants to come to the meeting in Arizona that they can physically attend the meeting in Arizona. We have to provide an agenda for the meeting in advance of the meeting. We're going to be talking about that in a few minutes here under the new legislation. Previously, the law just said we had to have it present at the meeting and handed out, but we're going to be talking about that, a new change in the law. Just be careful, because I think the open meeting law in Arizona, it's pretty clear that the legislature has spoken. They want owners to have a right to be there and listen when the board is deliberating and voting on issues. That's the intent of this law. They don't want boards doing things in secret by email, discussing a quorum of the board, discussing items outside of the board meeting. That's the intent of this law, is to stop that. They want people, if homeowners want to attend the meeting, they should be able to listen to every discussion of a quorum of the board discussing association business, unless it's an executive session topic. Um, okay, don't forget also a few little kind of final things. Owners are allowed to tape record or video record association meetings if they want to. If the board would prefer to do it themselves, they can do that, but they have to give a copy of the recording to the owner if the owners want it. And if the association says, no, you can't record it because we are, then they have to make sure to make that recording available to the owners. Because the owners have a right to have a recording. I think that's really pretty much it on open meeting laws. We have a great cheat sheet that we shared with you on recording meetings. If you have that as a problem, we give you some suggestions. You can pass some rules regarding how they do it, et cetera, if it's an issue in your association. Kind of our last topic here, we have a great cheat sheet that I want to just remind you of about, the open meeting laws. And, a common question that I get is, can tenants attend board meetings as the owner's representative? And my comment is they can only attend it if the board allows them to, or if the owner designates them in writing as their designated agent. Same thing, tenant cannot sit on the board unless, it allows non-owners to serve on your board, which is very, very few and far between that we ever see that. And so those are just kind of some main topics on that, the most common questions that we get. So we just did kind of a quick sprinkling of those. Okay, let's talk quickly about the new legislative session. So the 2024 legislative session ended on Saturday, June 15th. As of today, 7 HOA or condo bills have been signed into law. So 90 days from June 15th. So I don't know what the exact date on that it's going to be. So July, August, September. So probably mid-September, we're going to have all of these new laws are going to go into effect. We're going to be talking about these new laws and analyzing them further as, the effective date of these laws comes into play, which it looks like it's going to be 9/14 is going to be the effective date. My office is the best. They knew I was looking for that date in my head and they just put it right in my screen. So there were 7 bills that were passed this year. I'm just going to spend a minute going into overtime here before we do the questions, talking about what these bills, generally speaking, what these bills talk about. Okay, the first one is House Bill 2119. This deals with association fees. And basically, this is a law that is going to limit when we can charge transfer fees, and it's not going to really apply to in a very broad way. Okay, so don't panic. Basically, it's just going to take when there's conveyances where it's like interfamilial conveyances. You're not going to be able to charge a transfer fee when the husband transfers it to the wife, or those would be the examples that I would give. Another example would be is if the title has only nominal actual consideration. And this is again like parent to child or husband to wife, grandparent and grandchildren. So that's one example of when we will not be able to charge a transfer fee if your association has a transfer fee as part of your CC&Rs. Another time would be if there's no consideration or nominal consideration and the transfer is between like a subsidiary to a parent company or a parent to a subsidiary company. So it could be from like an LLC to the member or the member to the LLC. So we're going to have to look at going forward as of September 14th, if you're trying to charge a transfer fee, there's going to need to be some analysis done. Is it set up right under the law in your documents? Number one. Number two, if it is set up right under the law in your documents, is it one of these carve out ones that you can't charge a transfer fee on? And I would say probably the most common ones are going to be, where you're transferring it and there's nominal consideration or no consideration, meaning it's free, the transfer is free, you're just doing it for a familial relationship, or maybe if you're doing an inter-business transfer, maybe to get a loan or something, you're not going to be able to charge a transfer fee. So when the question comes up, make sure you reach out to your legal counsel to determine, okay, whether or not this is something that can be, we can charge a transfer fee for. Okay, next one is on condominium interior improvements. Basically on this one, an association cannot prohibit an owner from making alterations. to the unit, and this is only going to apply to condos, like I said, in a way that's going to disturb adjacent unit owners, as long as they do things to minimize the disturbance to the adjacent unit owner. So, maybe your association's documents in your condo say that you can only have carpeting on the second floor. This is going to come into play in those situations. So we can't prohibit a resident or an owner or resident from making a change in their condo, but they're going to have to get permission, obviously, through the architectural approval, and they're going to have to do it in a way so as to not disturb any of the adjacent unit owners, and minimize or eliminate the disturbance. So example, somebody wants to put in hardwood floors, we may be able to require them that they use special, corking or whatever, so that it doesn't, cause noise to the unit below. Also, the association cannot prohibit a unit owner from any manner of decoration in the interior of their unit. That's so broadly worded, I worry about that, but that's what it says. We're also going to talk a little bit about, I'm kind of further analyzing this law. This is House Bill 2648, talking about when we can lien and not lien. There's going to be some changes for these extraneous charges that are not assessment related. So we're going to be analyzing that further, what exactly you can lien for as of September 14th. We still can lien for unpaid assessments, but there's a question mark now as to whether or not we can lien for attorney's fees and late fees and collection costs. So we're going to be, stay tuned on that. We're still kind of internally debating that in our office. The next one talks about meeting agendas. I briefly mentioned this a minute ago that applies to planned communities and condos. The secretary has to provide in an association an agenda for every meeting, of the board. So that's just an additional requirement. I know many of you are already doing this, so that shouldn't be a big deal. And basically, what you can do on that is that you can send it out with a notice. That's what most associations are doing. Then we have a bill on, let's see here. Then we have a bill, there's 7 bills this year, lots of different bills. The next one talks about, it's for planned communities only. And it talks about declarant control and, giving specific requirements regarding, how declarant control is going to be handled, and providing a date for when declarant control ends. So that will be another thing that we'll be closely following. And we're going to be putting out our cheat sheet on this topic. So if you're an association that is under developer control right now, there's going to be much firmer, timelines as to when the transfer of control is going to take place, et cetera. Flagpoles, this is going to apply to planned communities and condominiums. And basically, this talks about bracketed flagpoles that are on the walls and how those are going to be handled. And it puts a limitation on how many, bracketed flagpoles that you can have. So basically what it says is associations may limit members to 2 flagpole holders on their property. Then Senate Bill 1432 talks about, amendments to associations documents, and says if you have any language in your documents that potentially could violate the Fair Housing Act, that these amendments can be changed by the board without approval of the membership. So if you have discriminatory language, et cetera, that's something that your board may be able to remove, without a vote of the membership. So that's a good law. I don't think it's going to apply to many of you, but that's just a quick overview of the new laws. We're going to be pumping out our new cheat sheet on this in the next week or so as we're finalizing our language on it. I don't think there's anything we can't live with this year on the new legislation. So it's just a matter of, making sure everybody knows to get those agendas out to the membership with the notice of the meeting. And we'll just give you some tips in our final cheat sheet when we put it out this year. So in closing, I would say long legislative year, lots of bills introduced regarding associations. We got 7 new ones. I think we can live with all of them. And, we'll be pumping out more information as we get closer to the effective date, which is September 14th. 2024. Thank you everybody for being here today with us. Appreciate you caring about your associations. wanting to learn more about the new laws, wanting to learn more about, political situations and associations and our most commonly asked questions. Just a couple housekeeping matters. There will be no live First Friday event on July 5th, Friday, July 5th. Why? Because it's July 4th, the day before, my favorite holiday of the year. And we usually get very low participation on the holiday week like that. So we're not going to be having a live virtual First Friday event on July 5th, but we'll be resuming that again as usual in August, the first Friday in August. Our next virtual event then will be class number 7 of our 2024 Virtual HOA Condo Academy, and that's going to be on Tuesday, July 16th at 11 a.m. We're going to be talking about amending CC&Rs, how to implement rental restrictions, and how to create a budget for your association. So those are going to be really good, relevant topics for you as you navigate summer months. Lastly, we ask if you wouldn't mind, please consider leaving our firm a review on Google or Yelp. We are sharing a link in the chat on how to leave a review. We're always happy to get feedback from all of you about how we can improve the classes, or if you like the class today, or if there's something that you'd like us to teach on in the future. That's a really great way to provide us with that information. So appreciate you doing that if you're so inclined to do. We have a link that we'll be sharing with you on how you can give us a review. Just some concluding remarks. Stay cool over the summer. I hope you all have a wonderful 4th of July holiday. Thank you so much for being here today. I think today might have been one of our largest attendee days. So thank you so much for being here today and caring about your associations and wanting to learn more. So take care, everybody. Have a safe summer, safe 4th of July. And we will look forward to seeing you in August for our next virtual HOA seminar. Take care, everybody. Have a great holiday.